As the saying goes, if one isn't outraged now, it might never occur. In a 5-4 decision, Chief Justice John Roberts Friday night sided with leftists to rule against California churches suing Democrat Governor Gavin Newsom for his COVID crackdowns. Not once citing the actual Constitution, he sided with the leftists against the founding document that created his Supreme Court itself, and he sided against the free practice of religion. It's a ruling that echoes his shocking 2012 vote with leftists to claim the Obamacare individual mandate and its federal penalties were constitutional. And it's as absurd and infuriating as that abysmal decision, relying not on any single word of the actual Constitution, but on previous rulings, many of them among some of the worst in U.S. history, rulings not even pertinent to the issue at hand. The issue is that since March 19th, when Newsom issued his stay-at-home decree, churches and other California places of worship have been prohibited from operating as their pastors and congregations chose. Even now, after Newsom on May 25th beneficently blessed churches with permission to congregate with no more than 100 people spread apart as Newsom dictates, these religious Americans are being restricted from the free practice of their beliefs. Against Newsom's commands and after being insultingly rebuffed by the Ninth Circuit Court of Appeals, South Bay United Pentecostal Church and numerous others on May 23rd asked the Supreme Court for emergency injunctive relief.
The South Bay Pentecostal Church in Chula Vista is now seeking guidance from a higher power in their fight to reopen.
We are wanting our governor and our state to no longer discriminate against churches in their phase-in plans.
Pastor Arthur Hodges tells Fox 5 their lawsuit is now in the hands of the Supreme Court after the church's quest for an injunction of the state's stay-at-home order was denied by a federal judge and the Ninth Circuit. Reopening churches has been at the center of attention as of late. The CDC just released COVID-19 guidelines for places of worship, including intensified sanitation, face masks, and social distancing.
But treating the plaintiffs and the rest of America like romper room children, the majority, composed of Roberts, Ginsburg, Sotomayor, Kagan, and Breyer, dispelled the immense problems of Newsom's crackdown, first pointing out something that wasn't even pertinent, the difference between an injunction and a stay. Why Americans need to know about a stay is anyone's guess, since a stay wasn't requested, and it is completely irrelevant to the case. This was a request for injunctive relief against state action. It's pretty simple. But adding insult to injury, Roberts and his leftist cohorts went on to offer this amazingly errant nonsense. Our Constitution principally entrusts the safety and the health of the people to the politically accountable officials of the states to guard and protect. Which anyone who's read the Constitution can mention are words that aren't in the Constitution. The Constitution is clear. Its preamble states the intent of the founders to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity. The text itself, specifying the branches, enumerated powers, and amendments, lays out how they intended those goals to be achieved. By general welfare, they meant prosperity through voluntary market exchange, not redistribution of wealth, since that makes all residents potential targets for government tax theft and runs counter to the goal of ensuring liberty, justice, or the philosophical rationale of the state itself, that being property and liberty protection against attacks by other people. No, the current majority of the Supreme Court judges didn't cite a single word of the Constitution, literally not one word in this 11th hour late Friday ruling. They lifted their magic phrase about health and safety of the people from a terrible, insulting, and dangerous 1905 Supreme Court decision in a case called Jacobson v. Massachusetts, a case that saw the court invent a public health police power for states that doesn't exist at all. To stress the point, Newsom's edict is an inarguable attack on the free practice of religion assured in the First Amendment. It's an attack on the Fourth Amendment, protection against warrantless search and seizure, on the Fifth Amendment, assurance of due process and prohibition of property takings done without just compensation, on the Sixth Amendment, assurance of fair and speedy trials before an impartial jury of peers, on the Eighth Amendment, prohibition of cruel and unusual punishment. Of course, there can be no punishment if there hasn't been a trial, on the 14th Amendment's reiteration of the Due Process Clause, and on the Contract Clause, which is found in Article 1, and it's easy to read. And in their zeal to give pantomime cover to Newsom, Roberts and his leftist Supreme Court cabal actually cited not the Constitution, but a 1905 ruling that backed, get this, the forced vaccination of a Massachusetts man, and invented out of whole cloth this fictional, mythical public health police power they claim the state possesses. This can't be stressed more intensely. There is no such power. Not only does the Constitution not provide for it, most of the Bill of Rights stands in opposition to the idea that a state can infringe on an innocent person's bodily integrity or private property, on the right to speak, the right to associate, the right to have a contract fulfilled, the right to a trial by jury, and to equal protection under the law. There is absolutely no constitutional public health police power, least of all one allowing forced injections or stay-at-home orders or closures of churches or of businesses, or prohibiting public gatherings to protest these government actions themselves. And in addition to there being no constitutional provision, there's no logical basis for this at all, and there is no philosophical foundation for the term public health at all. There is only individual health. The so-called public in question here is just a word applied to individuals. The state isn't a person and can't be healthy or unhealthy. What these obtuse judges mean is the health of the group. But the group is composed of individuals. When it comes to liberty, there is no public. And to claim the power to threaten the liberty of any single individual in order to protect other individuals puts all individuals at risk of being the person singled out. Such a system is not internally supportable, logical, or universalizable, for it actually makes everyone a potential target, undermining its own so-called rationale. If the state has a, quote, public health police power and can tell people to stay at home or not congregate in churches unless they show they aren't a risk of infecting others with a deadly pathogen, what happens when something like COVID-19 is gone, but common colds still exist and a portion of the population is immunocompromised? Can Newsom demand that all citizens test negative each day before the government lets them escape their homes? Does every transaction needing human contact with an item also require a government disinfection analysis? After all, if the state has a police power to protect public health, as they argue and support in Roberts' twisted decision, there's always a risk that a weak person could contract a natural pathogen from another human being. Can the government force you to eat, drink, and sleep as it commands? All being done for public health?
That power would set me up above the gods!
Arguing in favor of such nonsense is not only fatuous, it's tyrannical. And it's precisely what Roberts and his leftists backed on Friday. By the way, hats off to Justices Thomas, Kavanaugh, Alito, and Gorsuch, 4 men who bothered to read the Constitution and consider its philosophical foundation. Government does not exist to protect public health. It supposedly exists to stop people from infringing on the rights and property of others. But of course, the organization that does that the most today is the government, especially if you live in Gavin Newsom's California. This just pisses me off. I get so angry. These guys, wow.